Good morning, everybody. Welcome to the second lecture of this course. Again, we want to thank Professor Liz TIPPETT for her generosity to join us. And, well, just it's up to you. Oh, Professor Alberto. Just about, no, it's okay. It's okay. I'm trying to call you up.
Good morning. Let's see you.
Okay. Now we are really ready to start. So, please, Professor Liz.
Yeah.
Mm.
Thank you for coming today. Oh, let me turn on the microphone. Here we go. So today I'm going to talk about the influence of cultural context on dispute resolution systems. So today's lecture is called Kaizen Arbitration. Kaizen is actually a Japanese word that has become actually somewhat popular in the United States. And I'll explain more what it means, but it means continual improvement, essentially. So, so I call this lecture Kaizen Arbitration because I end up describing a Japanese arbitration system that over time has been designed for continual improvement. And I'll explain that a little bit more. So if you remember from yesterday, I was talking about how ADR reflects the justice system in which it resides. But ADR also reflects the cultural context in which the dispute resolution system resides as well. And it has subtle effects on the way that the dispute resolution plays out over time. And so I'm going to provide you with two case studies. One is my best attempt to describe the American cultural context around arbitration and how that has influenced the way arbitration is implemented in the United States. And then I will also attempt to describe a Japanese system that we observed during the Brazil-Japan seminar, and to the extent I'm able to describe how the cultural context influences the way that system has been designed and implemented and changed over time. So this is the Japan Insurance Association, who runs the insurance arbitration system in Japan. So you may recognize some of the people in this picture because it's mostly Brazilians on either side of the table, and then you can see at the head of the table is the leadership for the Insurance Association in Japan, and they were the ones who were explaining to us how their arbitration system works.
George Bolsinha's video and the left side.
Okay, so well, let me tell you a story. So when we went to visit the Insurance Association, they were describing their arbitration system, and to me it was very unique and very interesting, and in many ways quite superior to the American arbitration system. And so I was very excited and impressed to hear about their arbitration process. And so throughout the presentation, I would say, wow, this is really amazing. This is so much better than the American system. And they did not react at all, which I thought was maybe a translation issue, partly because the person who was translating what I was saying refused to translate it when I would say that it was better than the American system. And, you know, I think this was, again, part of my ignorance of the cultural context. So I later learned that all of the Japanese executives spoke excellent English, but they did not want to be embarrassed if their English wasn't perfect, so they did not reveal the fact that they understood everything that I was saying to begin with. And I think also I kept saying to the translator, tell them that this is a great system. It's so much better than the American system. And he would just ignored me. And afterwards, when we were at the elevator, I was at the last opportunity, I said, but this system is so great. It's so much better than the American system. And he said, that's not possible. And I said, why? And he said, because it is the American system. And I said, I can assure you this is not the American system. But it turns out that the Japanese model was imported and designed on the American model. But what has happened, it has diverged from the American system over time. And so now it really does not resemble the American system at all. But I think maybe they were protecting me from looking stupid by saying this is so much better than the American system because I don't realize what the American system is. Or I didn't realize, you know, that the Japanese system was modeled on the American system and they didn't want to embarrass me. So I think they were attempting to protect me from my own ignorance, which they failed to do because obviously the Japanese executives understood every time I said that I thought it was better. Why is the slide not going forward? Oh no, it's frozen. Computer's frozen. Yeah.
Start it?
That's kind of a drastic intervention. Oh, here we go. Okay. So you can see, so this is my model of essentially what happened is sometime around World War II, you know, when the Imperial Americans imposed their legal system on the Japanese system. It was the same, but both systems actually have evolved over time, and now they don't look very similar. And part of the reason they have evolved, I think, is they're adapting to the cultural context in which the dispute resolution system resides. So part of this is based on a model that we use in the United States, and I don't know if you're familiar with this research on high context versus low context cultures. So this model describes high context cultures where most of the meaning, for example, most of the meaning in language is embedded in the context. And so people infer from the context of a discussion what is happening, and you don't need to communicate it as expressly, for example, in the course of conversations or in the course of contracts. So one of the things they describe is in low context cultures, contracts are very elaborate because you're not inferring sort of some of the relational aspects and the course of dealing. You're having to spell everything out explicitly, or the language is spelling everything out explicitly. In high context cultures, everything is embedded in the context. There are rich social relationships, rich social hierarchy, strong value on self-control and social control, and you know, information. There's deep meaning in cultural interactions. Whereas low context cultures are very individualistic, alienated, fragmented, less social hierarchy, less social control, and communication is more explicit because the ties are not as rich between individuals. And so I think part of what is happening is the American culture is considered perhaps the most extreme low context culture. And Japan is considered a high context culture. So here are a few examples of differences. So in the United States, we have a saying, the squeaky wheel gets the grease. And so that's a way of saying that in the United States, you're supposed to speak up and become troublesome to other people because that's the only way to get things done. Whereas in the Japanese system, the saying is that a nail that stands out gets hammered down, which is that it's, you know, problematic to stand out. So in Japanese culture, there's a strong motivation to save face, and I'm sure you will realize from our president that there is no such motivation in the United States, and that our culture is very shameless. So as you may know, my mother is Japanese, and so I was raised in a somewhat of Japanese household. So I have a strong sense, I guess more than Americans, of it's important not to, you know, bring shame upon your family or, you know, your organization. And but this concept is very alien in the United States. So when I am at work and I say to my colleagues, oh, that's shameful. You should be ashamed of yourself. This is terrible. I'm so embarrassed on your behalf. Like, aren't you ashamed of what you've done? My colleagues are like, we don't know what you're talking about. And they tell me, Liz, you are very shame motivated. And because they are in a cultural context where they are not at all shame motivated. The idea of being ashamed or being embarrassed, that is not like an important part of their lives. So also, the American, culture is not only to display feelings, but even to pretend to have feelings to get a reaction out of other people, as opposed to, to control your feelings in order to protect the people around you. And of course, the stereotypical American negotiating style is an American negotiating style of dominance and competitiveness, as opposed to conflict styles that are seeking collaboration or compromise over time. So I guess my question for you today is, where would you put the Brazilian culture on the spectrum of high context versus low context? What do you think? You think so? Why do you say that?
Because I think we have no shame less to show our feelings. It's very explosive.
Okay.
The temper is very present in our discourses. So it's
Okay.
my opinion.
Other thoughts? Yeah. Okay.
Collective.
Yeah. Other thoughts? Yeah. Okay.
We get this impression that I'm closer to America or North America. Talking about Canada and this culture.
I think all cultures are on a spectrum, so they may be somewhere in between. And I think that's a good point, that there are also regional differences. So, for example, there are regional differences even in the United States. So, New York City has a very low context version of culture compared to Oregon, for example. So when I was a lawyer in New York City, if you were in a legal dispute, you would think nothing of picking up the phone and literally yelling at the other side of the dispute and telling them they're wrong and they're idiots and they need to fix what they're doing, or you're going to call the judge right away. This was, and you would yell at them and then you would hang up the phone and you would say to yourself, oh, that was a good call. And in Oregon, you would never do that. And in fact, there have been problems actually of New York lawyers who move to Oregon and they'll call someone and yell at the phone, and that's the end of their career, because that is like the rudest anyone has ever behaved in Oregon. And in Oregon, no one yells, and they're very collaborative in the legal community. So there are also regional differences for sure. Hmm. Hmm. Okay. Yeah. Anybody else have thoughts? Okay. Okay, so I argue in this presentation that the arbitration system reflects the cultural context in which the arbitration resides. So, so here's a definition of arbitration, which is private dispute resolution involving a third party agreed upon by the parties, usually agreed upon in the contract or some process in the contract for arbitration, who renders a decision on the merits of the case. Now, arbitration can be binding or non-binding. So non-binding is when the parties do not have to necessarily abide by the decision of the arbitrator. And binding is where it's like a judge. Once the arbitrator issues his ruling, you can't appeal. You have to do what the arbitrator says. American arbitration is very adversarial, isolated, and rewards dominance and conflict. The Japanese arbitration system, at least as described in their materials, it was still adversarial, but there were limits on the respect in which it was adversarial, but it was very closely embedded in the lawmaking system. And it also, I mean, it also, to some extent, rewards fairness. I mean, there are a lot that these two systems have in common, but to the extent it differs from the American system, there was some mechanism to reward fairness in the process. Okay, so first I'm going to talk about the American legal cultural context. Okay, so these are the core American ADR values. And these values are typically associated with mediation, but you can also see they are strongly reflected in the way the arbitration system has been designed and implemented over time. And also, these values are also somewhat eroded in the arbitration system as well. So the first aspect is voluntariness. And we talked a little bit about this yesterday when we talked about consent and self-determination. The idea is if you're going to ADR, you choose ADR. And what makes ADR different and special from litigation is that you have gone there in a voluntary way. And so much about the way ADR scholars evaluate ADR systems is whether they are voluntarily chosen. The other core, oh yeah. Yeah, well, so it's theoretically possible, but the types of arbitration I was describing yesterday almost always are binding arbitration. But I think there are sometimes court-ordered arbitration can be non-binding. It's up to the parties. The parties can always choose for arbitration to be non-binding. The reason why American contracts generally aren't non-binding is because it doesn't really save you money. It's like, if it's non-binding, why do we go through all this trouble? And the whole reason that American companies like arbitration is so that you can never go to court. But if it was non-binding, maybe you could go to court. So you sort of, yeah, you could go to court afterwards, right? So the binding arbitration is just considered more efficient. Yeah. Okay, so the other idea that is very central to the American ADR system is neutrality. And that is the idea that the person who is making the decision or the person who is serving as a mediator is not affiliated with the parties in any way, has no interest in the transaction in any way, and is not going to take a side. They are only there to be in the middle. So this is an analogy that you hear a lot in American culture. They're just an umpire in baseball. So baseball is not as popular as it used to be, but the umpire is the person who calls a strike or a ball when they're throwing the ball, and they're considered to be neutral. So this is the American ideal, as being an umpire. You're not going to get any money or any winnings at the end of the game. You're just calling it a ball or a strike. This is the American ideal. And that analogy is also been applied to the ADR context. And the last American value associated with ADR, which has become increasingly problematic over time, and I'll talk more about the Me Too movement on Friday, because I think it's also implicated when we think about it, is confidentiality. But the American ADR system strongly values the idea of privacy and the idea that information from one ADR context will never be used in any other context. It's like a bank vault. You're there for your transaction. At the end of your transaction, everything is locked up, and you can be 100% assured that the arbitrator will never talk about your case ever again, and nothing will happen. It belongs to you. It's like your personal individualized bank account. And one of the key values that ADR brings to litigants is the idea that it offers them confidentiality if they want it.
You say that to a certain extent they don't trust the state
Yo, that's true.
It's
Yes.
private way to-
That's true. So, I mean, obviously, the American culture is extremely distrustful of the state, extremely distrustful of government. You know, and this was also surprising to me. Like, I grew up in Canada, where Canadians have a lot of trust in the government. They have a little bit of suspicion, but you know, they essentially trust the government. And when I got to the States, and I went to college in the States, all the other students were like, even students who were very liberal, very progressive, they all had extreme distrust, extreme cynicism in government, and the idea that government would fix their problems or represent them well. They, in general, extremely suspicious of state intervention in general. And so I do think that their obsession with confidentiality is to some extent related to their distrust in government and their distrust in institutions in general. And they have more trust in private transactions and private relationships.
As well as voluntariness.
And voluntariness, right. Right. I think that's true. Yeah. So here are sort of a spectrum of ways that ADR scholars have thought about consent. So I'll give you a minute to read this slide, and then I can explain. Okay, so I'll explain what each of these are. This is most of this is actually from my colleague Jen Reynolds' article that I cited yesterday on luck versus justice. She has actually a very good theoretical breakdown of thinking about different kinds of consent. So on the left, self-determination, that's the one that you see the most in mediation trainings, and this is a core mediation value. And it is the idea that ADR is empowering to people because it gives them the right to make their own choices about their life. So self-determination, empowerment, you know, it's about free choice. Self-determination is about free choice. But there's a richer version of consent, which is informed consent. And that is not just that you agree to do something or to abide by this process, but that you're informed about the decision you're making. So for example, in the medical context, when we think of informed consent, like when you're talking to a doctor or you're going into a surgery, informed consent is the idea that the doctor tells you, here are all of the potential benefits of the surgery, here are all the risks of the surgery, knowing the benefits and the risks, do you still want to do this? And if they say yes, it's informed consent because you gave them the information they need to decide the best choice for them. And remember from yesterday when we were talking about small claims court, one of the problems that we've seen in small claims court is that when people are agreeing to a deal in small claims court, it's not very informed because people don't realize what their legal rights are going in. And so when they agree to a deal, they don't really have a good sense of what they're giving up by agreeing to, for example, a payment plan where they're paying the entire amount. They have no idea that maybe they might have won in court. They just assume they would have lost. Outcome consent, that's kind of not as a common term, but it's the idea that at the end of a process, you understand that you are accepting the outcome of the situation. And so that's kind of a process-related consent, that you choose this outcome instead of a different process. Okay, the last one is essentially legal consent or constructive consent. I don't know if you have a concept like this in Brazil, but this is basically a shortcut for saying the law presumes that you have consented regardless of whether the consent is meaningful or not. This is a very big problem in the United States because the law of arbitration over time has come to deem you to consent to things that you did not even come close to meaningfully give consent for. For example, the Netflix contract that we saw yesterday, so people don't ever read those contracts. You just have to press a button so you can watch your TV show. You don't know what you're agreeing to. It could say you agree to give Netflix your firstborn child. You don't know what that, you're just pressing the button. So, but the courts will presume that you have consented to that. So it's essentially constructive consent or legal consent. And this is actually a very long-standing idea in American law that actually goes back 100 years when there was sort of a change towards a more corporate-friendly version of the law and a very elaborated theoretical view of contract law where you just presume that people come to each contract freely and agree to all terms, and you just presume that the parties have negotiated over this and this is what they want, regardless of whether there is duress in the contract or whether you understood what you were agreeing to. And this became known in American jurisprudence as freedom of contract, which is the courts presume everyone is free when they're making contracts and they don't really think very much about what you actually know and what you're signing, or whether you've been forced to sign it. For example, if you're a worker and you start your job and they give you a paper to sign at the start of your employment and you just have to sign it. So what we've seen over time in the American arbitration system is that these other more meaningful forms of consent, like self-determination, informed consent, they don't really matter anymore. The courts are really just using a constructive consent when they're deciding whether someone has accepted arbitration. And that's part of how arbitration has eroded over time, is the courts care less and less whether you have consented to arbitration. And that's because of a statute that I talked about yesterday called the Federal Arbitration Act. And this is, it's actually a pretty short act, and this is one of the key parts of it. So basically what it provides is basically any contract involving commerce, which is essentially any contract, because if it's a business contract, there's some sort of interstate commerce. Any contract in commerce to settle by arbitration, and then it has a bunch of other stuff, shall be valid, irrevocable, and enforceable. So any arbitration contract will be valid, irrevocable, and enforceable. Okay, except legal principles for revoking a contract under state law. So that clause at the very end, except for grounds for a revocation of contract under state law, that was intended to allow states to apply their own contract law, because in the United States, it's individual states who decide contract law, and most of them are the same, but they have control over contracts. And so state law has a bunch of principles for invalidating contracts, like duress. So duress is the idea that you were forced to sign a contract, or that you were tricked, like fraud, like if you're defrauded into signing a contract, that's also a principle under state law. State law also has a principle called unconscionability, which is, unconscionability is this contract is so one-sided and so forced into that it should not be enforced. These are the state principles for invalidating a contract. And in theory, when this statute was written, you were supposed to be able to invalidate an arbitration contract under those state law principles that I just described, like fraud. Over time, however, the Supreme Court has become so commerce-focused that when states attempt to regulate arbitration contracts through their regular law of fraud, unconscionability, duress, the Supreme Court says those principles have been preempted by the Federal Arbitration Act. So what has happened now is states are essentially unable to regulate these contracts, even though they're supposed to have jurisdiction. And even though the Federal Arbitration Act includes a carve-out that is supposed to allow states to regulate these contracts under their usual law, the Supreme Court has said, no, those are preempted by the Federal Arbitration Act. You essentially have to enforce these contracts as written, no matter what, which is why, you know, we have gotten to a place where corporations can write virtually any arbitration provision they want, and it is always enforceable. Oh, questions? Oh, do people know what preemption is? So preemption is the idea that federal law supersedes state law. And it's this very boring, elaborate doctrine that if the federal law is very clear that it supersedes state law, then state law can't control. Now, under a normal reading of this statute, that's not true because there's a special carve out in this federal law that says state law applies. But the Supreme Court has gotten in this spiral over time where this exception means less and less, and they've just decided that this provision preempts any state efforts to regulate arbitration. The big turning point was a case called AT&T Mobility versus Concepcion. And that was a case involving consumers who had signed a cell phone contract with AT&T, which is a big cell phone provider. And they lost out on like $40 or something. Or they said AT&T defrauded them on $40. And it included the class action waiver I was talking about yesterday that says you can't bring a claim in connection with anyone else. And the court in AT&T v. Concepcion was very clear. You cannot bring your class action in court. You cannot bring your class action to arbitration. You can bring your class action nowhere. You have no class action. Go away. This is an article that Jean Sternlight wrote. This is a picture of Jean Sternlight at the University of Las Vegas. She wrote an article called Tsunami that describes how Concepcion basically cuts off access to justice. And so she was saying the Starbucks gift card that has a contract term on the back of the gift card, that would be enforceable. And it's true, it would be enforceable, even though all you did was buy a Starbucks card. You didn't even click a button. Under American law, which has become very favorable to corporations, they would like to enforce that. So remember yesterday when we were talking about consent in small claims court, because consent is such a core value in ADR, they use consent to excuse all sins. So that's also true of arbitration contracts. This idea that you have consented to this by engaging in this transaction or by buying this thing, you consent to whatever it is the contract says, the damage caps, procedural limits on how arbitration will be conducted, the fact that you can't appeal, and actually limits on appeal are actually built into the Federal Arbitration Act. And of course, class action waivers. And so because consent is so important, we're willing to excuse all of the problems in arbitration. This is the crazy logic behind the Supreme Court ruling on arbitration. And so you can also see this idea of consent is even influencing the way the Supreme Court is thinking about these problems. So it starts out with this idea that you consented to arbitration, and that is the basic principle underlying everything that the court says. And then they say, well, you consented to arbitration, but we all know that class actions are not good in arbitration. And so we are not going to presume that you consented to class actions because you chose arbitration. So those two things are inconsistent. So we're going to choose your consent to arbitration over the idea you might consent to a class action in arbitration. So that means you never could possibly agree to class action arbitration. And also you agreed not to go to court. So at the very end of the day, what is happening is the Supreme Court is saying you consented to no class actions in any context because that's what the Supreme Court thinks the parties want. The Supreme Court is essentially saying it would be a terrible injustice to what you want as a party to force you to allow a class action.
I was just wondering, would that be possible to think about a collective arbitration?
Yes, so the Supreme Court says collective arbitrations are not really consistent with arbitration, that arbitrators don't know how to handle collective arbitration. They're not good at it. It's not efficient. So why would you ever have agreed to that? Unless the arbitration provision says you explicitly agree to class actions, the Supreme Court presumes that you prefer not to have You prefer not to have it. Yeah. Okay, so the concept of neutrality has also been very influential in the American arbitration system. And part of the reason is because of the American value placed in the adversarial system. So the American adversarial system presumes that if you allow each party to fight their fight, again, they love the sports team analogy, like basketball, like baseball. This is for Americans, basketball or baseball or other soccer, other kinds of sport. That is the most fair process because both sides have an equal opportunity to fight. And so the best outcome in court, the best outcome in sport is that everyone gets to fight, and whoever wins the fight, that's the best outcome for everyone. So that is also true in arbitration, is the best arbitration or the best court system allows everyone to fight. And so the role of the arbitrator or the umpire or the referee is very narrow. All you're doing is deciding narrow rules that allow the parties to fight. They don't bring anything to the table. So just like in mediation we talked about yesterday, it would not be fair for the mediator to inform parties of their legal rights or to bring legal information to the dispute because that's not neutral. And and so then more narrow the role of the person making decisions, the better, the more fair it is presumed to be. And so the same is true of an arbitrator. They're not supposed to think about what's fair. They're not supposed to think about what the law is. They can't make any legal rule beyond what the parties bring to them. And they're just supposed to call the balls and the strikes like in baseball. Of course, one of the things that American scholars have pointed out when it comes to arbitration is that arbitrators are not 100% neutral. And the reason for that is because usually the company is the one that is paying the fees of the arbitrator. And oftentimes the company has the most control over who the arbitrator will be. And the companies are what is known as a repeat player. So a large company in its lifetime would be expected to go to many, many, many arbitrations. And arbitration is very lucrative for the arbitrator. And so one of the things scholars have argued is that arbitrators want to please the company because they might get more business for another dispute down the road. Whereas this individual plaintiff, they'll never see them again. But the arbitrator is a little bit biased towards a company that might hire them again, and because the company is paying their fees. So that's one of the respects in which neutrality is sort of artificial as well in the American context. Okay, so again, going back to this idea of confidentiality, which is also very core to mediation and also very core to arbitration. So even in the mediation context, there are even statutes and there are codes of ethics that prevent mediators from ever disclosing anything that happened in the mediation. As we talked about yesterday, there are also evidentiary rules that prevent parties from ever introducing anything that was said in mediation in a later litigation context. And so you also have sort of a similar confidentiality protections in arbitration. And that is the arbitrator is never allowed to disclose any information the arbitrator received in the arbitration. Never. Those are the rules from the American Arbitration Association. So the association that governs the arbitrator, they're not allowed to disclose it. The parties to an arbitration are allowed to talk. So if you are a company in an arbitration, you're allowed to talk about what happened. Or like the plaintiff is allowed to talk about what happened, unless there's a confidentiality provision in the arbitration contract. So sometimes an arbitration contract will say everyone agrees you're not allowed to talk about the arbitration, and then that they'll be restrained from talking. So you can also have a secret private arbitration as well. So there are strong legal mechanisms for enforcing confidentiality and for preventing the arbitrator from ever describing the information. So here's the actual official policy of the American Arbitration Association. Yeah. Okay, so this is my analogy for how the American arbitration culture works. Is this something you have in Brazil? These ball pits where children play in ball pits? Okay. This child looks like they're trapped in a ball pit. They look a little bit happy. So the American arbitration system, like each ball is one individual thing. And nothing from one ball ever goes to another ball. It's all little isolated capsules of information, of disputes that are resolved on their own. And nothing improves over time. You know, it's just very isolated, one-off, individualistic. And so the only thing that changes maybe is the companies get better and better at designing arbitrations that are helpful to them. But otherwise, you know, it's just a massive ball pit that people are drowning in. Very individualistic, not value-driven, profit-focused. Okay. So, first, does anyone have questions about the American system before I describe the, yes? No, they don't. I mean, and because arbitrations can't be appealed, you could have all sorts of strange arbitration awards. And they don't really, here's the only limitation, I guess I would say, is that arbitrators are people and they're professionals and they view themselves as professionals and they try and do a good job. So they're not going to intentionally like make an arbitration order that is very bad in their own opinion. But there are no other limits on what an arbitrator can and would do. And they're not constrained by public policy. They're not beholden to a government. They don't have any loyalty to anyone in particular. And again, that's part of the American value system, is this arbitrator is completely unattached. And that's part of, I guess, the American preferences around dispute resolution, is that the arbitrator wouldn't care about the public order. That's part of what Americans like about arbitration. It's very strange. Other questions? Yes. So public agencies do have their own dispute resolution processes and systems that are separate from the kind of arbitration I'm describing. The type of arbitration I'm describing is essentially called private arbitration. So it's private actors who are resolving a dispute that arose in commerce. Any other questions? Okay. So this is my sense of a dispute resolution process that they described in the Insurance Association of Japan. I guess I should qualify that this is based on what my understanding of what they were explaining to us, and also the materials they provided, but I haven't gone back and checked with them on whether this is correct. So there may be aspects of what I'm describing that will turn out to be incorrect when I go back and talk to them to fact check. Okay, so the first thing to know is that what the Japanese Life Insurance Association covers is more than what I guess in America we would consider life insurance. And I don't know what kind of insurance arrangements you have in Brazil. In the United States, life insurance is just like the money that your family gets if you die. Okay.
Just about the same.
Okay, so So the Japanese system covers many other different kinds of insurance. So the Life Insurance Association covers this umbrella of different kinds of insurance projects, or insurance terms. So, you know, various kinds of financial instruments issued by banks, also life insurance and various medical insurance and insurance against various kinds of medical problems. So, and it also included annuities. So, you know, in the United States, we don't really consider annuities a kind of life insurance as much. But so part of what they're presiding over is these complex financial instruments that are being offered in some cases to the elderly, and disputes arising over whether the bank or financial institution was being honest about the particular kind of insurance instrument that it was selling to the people involved. These are the different insurance companies who are covered by the Life Insurance Association of Japan. So these are all of the entities that are required to arbitrate their disputes through the Life Insurance Association. The Life Insurance Association is also kind of quasi-governmental agency in that the government that is responsible for regulating the insurance companies in Japan delegated its authority to the Life Insurance Association of Japan to hold insurance over these things. So in that sense, the association is sort of like a government entity in a way. You know, whereas in the United States, an association would have no affiliation with the government at all. But here they have some actual legal authority and jurisdiction over disputes involving insurance. Okay, so most of the cases that they're handling involve individuals who have a dispute with the insurance company over what they have paid for and received, and 20% of the claims involve elderly customers. They also described conflicts with family members over who gets the payout from the insurance contract, or whether the family member consented to purchasing the insurance. The materials also describe cases of suspected moral risks. So I have not yet gone back to ask them about what they mean by suspected moral risks. But what I thought was interesting is that they care about moral risks, because, you know, in the American system, the word moral is not something you would ever see in any private dispute. It's not, you know, it's not part of the discussion. So it was interesting to me that they flagged these cases and that they have a category for like a moral dispute, and sort of the idea that they have to intervene and fix a moral problem, or the idea they have a moral duty to improve the way life insurance is offered and sold in Japan. So this was their diagram for how their system works. I'll give you a minute to look at it. Mm-hmm. FINRA. Oh, yeah, there's some really, it's kind of a little bit like FINRA, a little bit. Okay, so there were a couple of things that I thought were interesting about this system and the way that they even presented it in a diagram. One of them was they put, so the designated dispute system body, that's the Insurance Association of Japan. And I thought it was interesting that they put themselves at the center of this sort of complex web of relationships, that they view themselves as large and in the middle of mediating all of these different relationships. So at the top is the government agency, and they've been designated by the government agency to handle this. But they're really in the middle of the trouble. And they're in the middle to fix the trouble and prevent the trouble, which again is not how American arbitrators would view this. I mean, I think if you had an American diagram, it'd be like party A, party B, and then like a tiny arbitrator in the middle and no government agency. And that would be how they would think about it visually. So to me, it was interesting that they think about it where they are in the center of this web. The other thing I thought was interesting was it looks like they have a contract with the life insurance companies. And I like they use the word obligation. So they're sort of listing here are all the obligations of the life insurance agency to engage in these things. And the insurance association imposes all of these obligations through contracts on the life insurance company. And that obligation to cooperate, to accept procedures. So it looks like the body is setting the procedures. It's not really a matter of negotiation with the life insurance company. And that the user, so it's interesting also that they think of the customer as a user, like they're a client of the dispute settlement body, and that they're, you know, I do think they view their role as servicing the user, improving the user experience, sort of like a software user, and that they're there to represent or assist the user in the dispute, and to make recommendations of settlements in the case of trouble.
Service providers.
Service providers, yeah. Okay, this is the next diagram for their system. You can see my notes are also in the slide, so you can see I wrote non-binding arbitration ! Because they actually are able to resolve all of these disputes through non-binding arbitration, which, you know, is very surprising to me, because in the American culture the American culture does not have any deference to authority. So if you had a non-binding arbitration in the United States, it would not save any money, because everyone would get to the end of the non-binding arbitration and all the parties would say, well, that's just your opinion. Why they'd say to the arbitrator, that's just your opinion. Why should we listen to you? We're going to go to court. But here, the non-binding arbitration does seem to eventually result in a successful settlement. So it looks like there's a number of complaint processes beforehand that they try and resolve it informally. It looks like half of them are actually resolved before they ever get to the arbitration process. And then, so step one is all of the informal process. And then step two is when they actually start filing for arbitration and resolve it. It does seem they have a screening process early on, but they said very rarely are the cases actually screened out at the very start. So most of the cases do get all the way through some fact finding. Okay, this was another part that I thought was interesting on when do they hold hearings. So here's what they said about when they hold hearings. Okay, either party can say, I want a hearing, and the insurance association will accept the request for a hearing. If they say, I don't want a hearing, but they later change their mind, they can decide later that they want a hearing. Again, this is actually a version that actually places a high degree of value on consent and choice and self-determination. However, if the parties say, I don't want a hearing, the insurance association can force them to have a hearing if they think the facts are really problematic. I think going back to what we saw earlier with the suspected moral cases, I think this refers to suspected moral cases. So you can see in certain cases, it looks like these are sort of cases involving fraud, or when they're changing the terms of the policy retroactively. Or, I mean, this does seem to me like situations where, like, misconduct on the part of the company. It looks like even if the parties say they don't want a hearing, that insurance association will have a hearing, if they cancel the contract without cause, and then attempt a settlement proposal. So it's sort of a hybrid of consent on the one hand, but also bringing in these social values, moral values, cultural values to place limits on how badly the arbitration system can serve people, and place limits on the social costs of an arbitration system. And if they perceive there to be social costs associated with a dispute, they want to still hold a hearing to protect those social interests. And I'll explain more in a minute how they do that. Here is another example of how I think this system reflects a Kaizen approach. So Kaizen is about continual improvement. And maybe I should show this other slide first. So continual improvement actually is most famous in the auto industry. And this system has actually been adopted by American car companies over time. But the idea is that the person who is doing the work on the auto factory line has the most knowledge about what's going on right there and the best ability to identify potential improvements. And the idea is that if you incorporate and make small improvements over time and incorporate the feedback from the people who are building the cars, then you can improve the production cycle overall over time. So to the American eye, the most famous aspect of Kaizen is that anyone who's working on the line can pull a string that will stop the production line if there's a problem, because the idea is it's better to fix a problem at the moment it's identified than to take the car apart later and fix a problem, and it's much more expensive. But it's a form of empowerment for the people who are most knowledgeable, who are on the ground, to identify problems and suggest improvements that improve the system overall. And so the idea is if you do this long enough, you'll eventually have a better and more robust system over time where everything works better. So here's an example. You can see, how much the Toyota factory has become more sophisticated and complex over time. But it still places the people who are in the middle of the dispute or in the middle of the problem at the center, and tries to make the workspace best for them. So the same concept has been actually, I think, been applied to the way they approach the arbitration system, in my view, because they've worked on improving their arbitration systems slowly over time. And one of the ways that seemed evident to me was the way they treated the people who were using the arbitration system as a user and asking the user what they need and how to improve the system for them. And one of the things they did was notice that their elderly clients needed extra care and attention, especially as the population ages. So what they did was they opened 51 centers across the country to have a telehearing, so that people didn't have to travel very far. They could just go to their local hearing place and do the hearing by teleconference. But then what they realized is some of the customers could not even travel to the local hearing center. So this is so amazing. And whenever I tell this to American people, they can't believe it because it's so attentive. Is if the elderly person cannot leave their home, someone from the local office will take a tablet and get on the train and go to the person's home so that they can have the hearing in their home using the tablet and access the hearing that way. So you can see they've sort of made these adaptations over time to make the process more accessible and more suitable to the actual needs of the people involved. And this is not, going back to the ball pit. The ball pit has been the same. The ball pit has not changed over time. The ball pit disappeared. Okay. So they've done other things as well to help accommodate the elderly users. One of the things is they have gone back and they have issued guidance to the original insurance companies, and they've said to the insurance companies, we expect more of you when you are dealing with an elderly customer. If you have an elderly customer, you have to go and explain the terms of the insurance contract very slowly and very carefully to them in person. It's not enough to just have them press a button on a screen or to give them a paper to sign. We expect you to go and explain it to them in person. And also, we expect you, when you're receiving the complaints, when there's a dispute, if you have an elderly complainant, we expect you to sit and listen to them very carefully and take into account the circumstances in which they received the insurance policy and their state of mind at the time they filed the complaint. They also noted that in many cases, elderly customers need and rely on the support of relatives or other third parties to help explain the situation, but also to describe and present evidence at the hearing or at the original complaint stage about the state of mind of the person purchasing the insurance. To say, my elderly relative is very hard of hearing, or my elderly relative was okay when they signed the policy, but now they're having a lot of trouble understanding, or whatever it is. And so they've come up with measures to allow relatives and third parties to present evidence in support of the elderly person or to help understand the elderly person's state of mind. And again, this is very strange from an American perspective. They place the burden of proof on the insurance company to show that the elderly person signing the contract had capacity at the time they signed the contract. And so it's not just, well, remember what the American system is, we're just going to legally presume that you consented. We're not going to ask questions. Here it is, you, the insurance company, given everything we know about the problems in these transactions, you, the insurance company, have the burden to prove that the person who signed this contract had capacity. And so what you see is this system where the arbitrators provide feedback about what they're seeing and the problems that are arising to the insurance companies and the government agencies to improve the regulations, but also to provide guidance to the insurance companies about how to improve their systems and how to prevent disputes. One of the things that I saw throughout the materials was they kept talking about how to prevent disputes. And they're constantly working, again, on a Kaizen model. How do we prevent these disputes from arising in the first place? And so they're constantly providing guidance to reduce the frequency of these disputes. And again, that's very foreign to the American system for preventing disputes. I mean, you don't, yeah.
Yes.
Yeah. So this is similar to what I already said. So this is another thing I thought was really interesting. If they find complaints they find very problematic, they compile them and they deliver them to the board of directors of the insurance company. So, I mean, you could see that they have a very high power, high level position. They're not just delivering it to some low level worker at the insurance company. When they notice problems through their arbitration system, they're delivering it to the board of directors. And they also compile statistics and annual reports that is delivered publicly and on the website. The other thing they do, which I love, is they tell each insurance company how they compare to other insurance companies. So they say, you are not doing very well. You had 500 complaints. The other companies had like 200 complaints. I think you're not doing, like, you have a problem. Like, let's talk about how to fix all of your angry customers, right? And so it's the idea that the purpose of the insurance arbitration system is to improve the overall system of providing insurance. So they provide examples and vignettes of especially egregious cases on their website. So here's an sort of a graphic example of Kaizen, which is sort of the improvement of logos over time. So this is kind of how I think about this insurance model or the Kaizen model. As you can see, like this is the Microsoft logo over time. So you can see the Microsoft logo in 1985 was just a bunch of boxes. Although ironically, it's a bunch of boxes now. So this is a bad example. Of course, it's an American company, so that's why we're back in 1985. But the idea is, you evolve over time, you improve over time, and so, the arbitration system improves the insurance offerings over time. Okay, we already talked about Toyota. So, so the American companies realized that the quality of the Japanese autos was way better than American companies. So American companies actually have adopted this system extremely efficiently, and Kaizen has also become a very popular idea in startup companies. So there is a very famous book in American culture called The Lean Startup. And they have a Kaizen model in the book where they talk about the way to have a good startup product is to start with something that might not be very good, offer to a few customers, get their feedback, and continually improve the product, and have many, many versions of the product that improve over time as your consumers uses and as you get feedback from your consumers on how much they like it. And so I think this idea is starting to penetrate all areas of the American system, which is actually quite funny because if you look at the famous book on Kaizen, there's a famous book on Kaizen. They actually contrast the Kaizen model with the American model of market disruption and rapid growth and rapid implementation. But what you see now is like the American model of disruption is actually taking on the Kaizen model as well. So I guess one of the last things I wanted to say about this system is the limitations of what I know about the Japanese system. And here's why. I mean, some of my observations might be a translation where I misunderstand what they're explaining, or it might be that they are motivated to present their system in a particular way because of they're trying to present their system in a good light. The other thing that gave me a little bit of pause was they provided 6 examples of complaints from consumers, and they all involved, to some degree, a person who did not understand what they were purchasing and then were unhappy with what they got. And one of the things I noticed from the arbitration rulings was all the actual non-binding arbitration rulings favored the life insurance company, and they all ruled in favor of the life insurance company, that like actually they were sold what they were supposed to be sold, which to me seemed a little bit inconsistent with the way they were presenting what they do. But what seemed to happen was after the non-binding arbitration, they would then enter into a settlement, and then the settlement would refer to all of the mitigating factors that made the life insurance company look bad. So it seemed like maybe what was happening was they were issuing a non-binding award that favored the company, but then telling the company, you need to settle for this amount because you did all of these bad things that we're upset about. And so they would agree to something in the middle. So I still have a little bit of uncertainty around what kind of outcomes the consumers using the system are actually receiving, and whether it aligns with the way they were presenting the arbitration model. So anyways, so you can see over time that the Japanese version has been designed around incremental improvement, that it's systems oriented. So it's a system that's intended to be dynamic, that's intended to improve, and that it has systems to prevent and address exploitation by the insurance companies, and that it's publicly minded, morally minded, and focused on conciliation, whereas the American model is static, isolated, and quite vulnerable to exploitation and very adversarial. Okay, so that's all I have. So I'm ready for questions. Oh, actually, I have one question for the audience.
Go ahead.
So can you tell me, how do you think the Brazilian culture influences the way your ADR systems have been designed and implemented? Okay. Okay. Mm-hmm. 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 Right. Right. Yeah. Mhm. 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 Yeah. It doesn't. Yeah. Should we give people a time to talk in groups about this? Okay, so what I would like to do is if you could talk with your neighbor. And, oh, there's one more question. Yes. Hmm. 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 Um, so I think Americans think they are very quick to litigate because they have never seen the Brazilian system. And I think if Americans saw the Brazilian system, they would be amazed. And I think there are many Americans who wish they had the Brazilian system. So in the United States, we talk about access to justice and how many people can't afford a lawyer, and because they can't afford a lawyer, they can't really use the court system. And I think, I mean, Americans are so funny because they love to litigate, but they also hate the government, and the government like presides over litigation. And so, like, I think if they saw like the giant labor court, they would be very impressed. But then they would be like, but that's the government. So they would be like both sides. They'd be like, I love that you have so many courts, and also you're paying for the people. You're paying for all this. How can you afford to pay for those judges? So I think Americans like would like love it, but then they would be like, when they would think the court is the government, then they would hate it. So it's like they have this, you know, they love anything as long as they don't think of it as the government. And so I think they think the court system is not really the government, so that's why they love it and they love to use it. But once they start thinking about it as the government, then they hate it. So oh really? Really?
Yeah, it's the most important repeat player.
Oh, really? Wow. The American government litigates very sparingly because it's underfunded, and the Americans aren't willing to finance litigation by their government. Oh, that's so interesting. So maybe what I would like is if you could talk in groups about how you think the Brazilian culture influences the dispute systems and the ADR in Brazil, and then we'll talk more as a big group.
Good, very good, very good. It is the course is Texas. Second. Solid food. Shouldn't do. Yes, yes, and I'm responsible. Okay. Necessary too. It's just this promote joint initiative. And the problem equity. So very important. Very important.
Tudo bem? Fica bem.
Você vai até a sala dos professores?
Oh, yes. I want to talk about that on Friday. So they have internal systems. But of course, yeah, of course the internal systems are very biased towards because the employers are. So they have, so that's one of the things that we have to see. The employers do a poor job, right? Even though they have very elaborate so if they're not unionized, it's a complete system. That's it. If it's unionized, it's different. It's unionized, it's a making process. That's actually better. The unionized workers have much better access to much better. Hello. So I'm interested to hear what you discussed with your group. You did not suspect that this would involve you teaching me. Yeah, yeah, yes. Okay. 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 Oh. Wow. Hmm. Oh. Oh.
This very strong confidence that the party opposed to governance necessarily former really hypers.
Mhm. Mhm.
So this party necessarily needs to be, I would say, whatever happens, parties one there needs to be
Mm. Mhm.
very clear. Like, party goes and really
Okay.
arbitration.
Really?
Hmm.
Because why?
Like our law, the party in our consumer waiver. So it's not so not parties to
And an arbitrator won't fix that? Is that the idea? Okay.
personally.
Hmm?
I think maybe
Okay.
what kind of relationship or formal relationship with parties.
Mm-hmm.
I'm a labor lawyer, so and the labor that's very commercial. Lawyer always,
Mm.
which is not always true.
Mm.
It's not always true. We have we also have executives and
Mm-hmm.
so a lot of things are very true.
Mm-hmm.
As per our they
You know what's so funny is yesterday I visited the labor courts. And what was so interesting to me is the labor courts, like the actual courtroom, resembles American arbitration rooms. Yes, because in the American system, the judges are really far away from the litigants. They're up high on a stand. You cannot talk to the judge. You have the lawyers talk to the judge in very prescribed ways. You have a witness in the witness box. They swear an oath. The judge never talks to the witness, and it's very formalized, many rules, and it's in like this big, scary wooden courtroom. Whereas arbitrations are in a conference room usually, and the arbitrator will talk to the lawyers, but also talk to the parties, and they take evidence, and it's a little bit informal. And American arbitration actually, the layout of the room and the way the parties interact looks more like the labor courts actually. So it's interesting.
agree with everything he said, but not complimenting what he said. Uh, I also think when the parties are equal, like we have two people parties, two think they are not capable, we are not capable of solving the problem without putting it into a litigation.
Oh, okay. Huh.
We still need the state to validate what we are fighting about.
Really?
Yeah. Not no, but
Huh.
the thing is, some of the parties they are not be aware of their rights. So
Uh-huh.
they be okay, I can waive this right, but I'm not sure how deep or uh, what the range of the what I'm waiving. So maybe later on, oh, you got yeah, you got C or you got by cheated. So it agreement, and later he was afraid to that. So he
Oh.
wants to go to state, but the state always can be
Oh, wow.
and also might be, but I think the state most of the objects of the contract, most of the objects of the dispute, they state rights to rights, but rules of. So labor law, waivable rights. There is no waivable rights as we have learned, but after you got dismissed, all you can waive the court, but
Okay.
not waive the private.
Oh, okay.
That's where, and even for tax, some countries that I've heard about, they have like arbitration for tax.
Mhm.
So you cannot arbitration, tax cannot be arbitration because are not waivable with the
Hmm.
tax for the state.
Hmm.
They cannot negotiate the tax
Hmm.
with the people. So they state that there's a range of, I would say, matters or subjects that they cannot. Okay, this is always,
Oh.
you cannot negotiate, you cannot litigate, you cannot use ADR for that.
Hmm.
Because this is not waivable.
Hmm.
It's not yours. The state
Okay.
has to rule about it.
Wow. Other groups?
We are talking about labor.
Okay.
I explain another perspective. I'm working with labor, and when players, we call them there to a big aviation.
Okay.
So we had something like that with a bus company. There was a problem with fixing the time the worker was working. And so the judge came and talked with them. How can we do that? No, as a judge. Not Mateus. He's not a judge.
Mm-hmm.
When he was now he's a judge that he's bathroom. But he called them and would say, okay, let's see what's happening. So what can we do to fix it? So they organized the system of time the presence of the workers, and they organize everything without a process. So
Hmm.
I think when you have a balance of power, you can do another way of mediation.
Mhm.
You put it
Mhm.
together. Persons and
Mhm.
have problem with that because
Mhm.
yes, one has more power than another. But
Mhm.
if you work, if you think methodologies that it can improve the person has low power,
Mhm.
you can organize it.
Mhm.
As I
Mhm.
the Indians,
Mhm.
as we crime
Mhm.
and violence, you just see different ways. In Brazil, in arbitration mediation, we reproduce our litigation way to work. That's
Mhm.
the problem.
Mm. Yes. So
Here too.
I thought so I saw some of the conciliation court as well yesterday, and it was so interesting to me. It was so different from American conciliation, and I'll say why. So you may already know this, but so there's two judges. I'm told, I guess resolution 174 says you have to have a judge in the mediation process. So the judges are in their office and they have instant messenger with the mediators, and then the mediators instant message them when they need help, and then the judges go in and help with the mediation. This is, to me, this is not something I've ever seen before, where the judge is on call and they just go and help, and then you watch them go in and they say like, oh, well, maybe, how about this, how about that. So I guess it's part of the American thing of they don't like the pizza and the hamburger at once. They like them separate. But I think I'm curious to hear what you think about that way of doing mediation. Hmm.
So the judge can explain something that the conciliator can do. So we don't say law, the right for the person standing. So they called, come and explain something that the air couldn't do.
Oh.
When finished, the judge say, okay, and separate, okay.
Okay.
That's the position of the judge in this context.
Oh, okay.
And sometimes when Mr. John came,
Mhm.
there was a wrong way to work. And I said, Mateus, help them because you have to do something beautiful for them. When they're to work with them. So, but it just comes to finish when we have to say something about the law and not working.
Oh, okay. So I saw two mediations or conciliations when I was there. One, they were arguing about payment plan, and they seemed to be getting along okay. And the judge at the end just went in and kept saying to them, I mean, my Portuguese is not great, but I think he was just saying, yeah, that's okay, that's okay, yeah, that's fine, you can do that, that's okay, that's okay. And so I think he was just telling them what they had done would work. And then the other one was very strange because they were fighting over like $2,000, I guess. And when I got there, they seemed like they kind of got along. And the longer we were standing there, and the judge was there too, the more they were fighting, more and more heated, until it was like kind of an explosion. And the judge had to sit down and say like, well, maybe you can work this out. And I said, why were they? So for in an American context, if you saw that occur, the American story about why that is happening is that the parties were just putting on a show for the judge and getting angry because they think to try and make the judge sympathetic. But the judge told me that they were just fighting over a small amount of money and that it was ridiculous, and they would have been fighting whether he was there or not. And so that was interesting because they weren't looking at him at all when they were fighting. I mean, in an American context, if a judge walks in the room, everyone starts talking to the judge. It was very interesting to me that they were essentially ignoring the judge. And the judge had to actually insert himself in at the end when they were not making any progress.
Do you have any sort of conciliation process? I mean, this any sense, any special meaning for you?
No, I mean we have mediation.
Just mediation.
And then sometimes the judge will say, you go outside in the room and negotiate, and go away and come back in half an hour. That's, I guess, we have that. But we don't have these blended processes. But I think it would be very interesting to have a situation where you have a mediator, but if you have a contested issue, you call the judge in and ask the judge what their opinion is on that one issue, so you can resolve that issue rather than taking your whole dispute back to the judge. We don't have any, so I thought it was very efficient in that way. What do you mean? Mm. Yeah, I mean, we have settlement conferences, yeah, where the judge is the mediator, essentially. So we have that. Yeah. We do have some court-connected mediation, yes. Yes. So it really varies depending on how well it's funded. So the court-connected mediation for family law is very good. So they get referred to very good people who are paid by the government who only do family mediations for child custody arrangements, and those are very good. In other contexts, it's not good at all. So for example, when I was doing employment law, there was a mandatory mediation system. And the problem with mandatory mediation was you didn't get to choose when you were doing the mediation, and you didn't really get to choose your mediator. And so you would you'd be sent to mediation at a time that was not really good for resolving the dispute. And sometimes you get a mediator that wasn't knowledgeable at all. And so you just get frustrated that the judge made you go see this bad mediator.
I think we still have some other groups too.
Yes, other groups. They're shy.
Yeah. Lazy, probably.
Mm-hmm. Mm-hmm. Yeah. I mean, I do think the big weakness in the American system is the unavailability of legal information. And that really doesn't really almost have anything to do with ADR. But if you provided better legal information, the ADR system would work much better.
Yes.
Yes, exactly. Yes. Mm-hmm. Mm-hmm. Yeah. Yes, I agree. Yes. Mm-hmm. 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 Yeah. 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 You're right. Mm-hmm.
I stayed with now with Professor Constanza, you know, she was vice president of FREITAS,
Mm-hmm.
and show us about arbitration. And what seems to me, here in Brazil, our patients are like courts.
Mm-hmm.
There, the movies that show us, the arbitration was like informal. The testimony, we stayed together with the parts, and it was one day alone, just do
Mhm.
that and finish that one
Mhm.
day, the beginning and
Mm.
but here, our arbitration month, years, and we reproduce, I think it's about our litigation culture. The same as the court
Mhm.
works. No, how they
Are you talking about labor arbitration or private arbitration? Oh, labor arbitration. Okay, so in the United States, labor arbitration is a separate process just for employees who are unionized. And I actually haven't been talking about that at all. And the labor arbitration system in the United States is very respected and considered to be very fair by everybody involved. And that is because the workers are represented by a union, and the union represents the interests of all of the employees. So sometimes it doesn't work great if the particular individual employee has a problem that other employees don't have, because the labor union is not as interested in representing them. But the opposite is also true. So if the employee has a problem that is shared among many employees, the union will be very excited to help. And so the union will negotiate with the employer to try and resolve it. And if it doesn't work, they will have a grievance process, and the lawyer for the union or the union will represent the worker and the union at a formal labor arbitration. And there is a repeat player effect. However, the repeat player is both the union and the company. So the power is more balanced. And so they have labor arbitrators that they like, that knows how that company works, that is familiar with the needs of the workers and the company, and they work together to improve the situation. So the labor arbitration system in the United States is actually more like this Japanese version, because the union and the company are working together to improve the workplace overall and to have a better understanding of the collective bargaining agreement over time. So the labor arbitration system works very well and very efficiently and operates very happily outside of the litigation system. It doesn't produce case law, but the parties are, it's intended to govern one particular workplace in a long-term sustainable way. Yeah.
By the way, is everybody familiar with the difference between labor law and employment law? Labor relations and employment relations?
Oh, so in the United States, there's a very strong divide between labor and employment law. So in the United States, if you are a member of a union, labor law applies. And labor law governs collective bargaining, it governs strikes, and it governs a grievance process and labor arbitration. And so if you are a member of a union, you often have very many protections above and beyond what the American employment law system provides. So you are happy and pleased to use the labor arbitration system because you're better off than virtually any other worker in the United States. But it's a pretty small proportion of the workforce in the United States. It's like 8% of workers, something like that in the United States. For the other 92% of workers, they are only governed by employment law. And employment law provides very basic legal protections for everybody. And that the basic law in the United States, which you may have heard, is called employment at will. You know what employment at will is? So employment at will is this idea in the American law, which is a bit crazy, which is you can be fired from your job anytime for any reason or for no reason with no notice. It's just like you are done. Like there's no, this is the baseline American law. So if you come into work one day and your boss is feeling grumpy and, you know, and they're just like, go, you're fired. Like that's okay. That under employment at law, that's okay. Or, you know,
We have
okay.
absolutely the same. It's the rule.
All right, you can, so employment at will, you can be fired. So that's the baseline rule in America. However, there are piecemeal exceptions to employment at will. So one of the biggest exceptions is anti-discrimination law. So the decision to terminate someone or to hire someone or to pay someone a particular way can't be motivated by the person's race or religion or color or age, gender, veteran status, disability. So there are certain protections based on your status that your employer can't make a decision based on that status. So that's the one big exception to employment at will. And then there are other very smaller exceptions. So for example, if you're a whistleblower, if you complain about illegal activity and your employer fires you for complaining about illegal activity, you're still fired, but you can bring a lawsuit. That's also true for discrimination. You can still be fired, but you bring a lawsuit to get money if you're fired. And then there are some other basic protections for all workers under employment law, like wage and hour law, minimum wage, overtime. And actually that law is kind of similar to Brazil. Yeah. Criminal law is completely separate as well. Are you asking about ADR in criminal law? Yes. So, yes. So I'm not an expert in criminal law, but one of the things that has happened in the American system is that trials are very expensive in criminal law. So almost all criminal cases are settled through a plea bargaining process, which sounds like a good idea. But the problem is the American criminal system is overburdened. And the criminal laws give every person the right to have a lawyer, even if you can't afford it. But the lawyers that are for free, these are called public defenders, are very, very busy. And they, for any given one day, they might have a huge stack of cases that they have to get through. And so when you're talking to your lawyer about your case, your criminal case, you might meet them the same day as your trial or, you know, right away. And they have to get through the stack of cases. So your lawyer's going to say, well, I think you should accept, you know, this jail term, and won't really have time to work up your case. And, you know, you just and so your defense lawyer negotiates with the prosecutor for how long they think you should go to jail. And that's the end of it. Now, if you have a lot of money and you can pay for a private criminal lawyer, then you can get a trial if you want, or you can maybe have a better negotiation or more investigation for the facts and present a better argument when you're bargaining with the prosecutor. But if you're in a typical criminal defense situation, you might not have a lot of opportunity to investigate your case and to argue your case just because of resource constraints. So again, it's another system where plea bargaining could work very well, and sometimes it does work very well, but it's constrained by this larger system where there's not enough resources to provide a strong legal defense if you're using a public defender. For outside of labor arbitration? Okay, so let me get back to employment law. So these are people that are not unionized, who are just part of regular employment law. So all these other employees, 92% of employees, in theory, these employees all have access to the court system. And in theory, if you suffer discrimination or retaliation or overtime claim, these 92% of employees, they get to go to court. But what happens is employers like to use these arbitration clauses because then they can waive the class action claims. So employers will say to these other 92% of employees, when they start their job, here's your contract and you're at will and you have to sign this arbitration provision if you want this job. And so these 92% of employees can't really go to court anymore unless they happen to have an employer that doesn't use arbitration. So they can only use private arbitration if they have a lawsuit against their employer. And that becomes very difficult if, for example, you have a wage and hour claim for $1,000, you're not going to be able to find someone who's willing to represent you outside of a class action for $1,000. So you're not going to be able to bring your overtime claim. So the problem of these binding private arbitration provisions is really for those 92% of employees who don't have access to labor arbitration, and so they're stuck in private arbitration. Yes, I mean it's not very good. I mean, if you're not subject to arbitration, then you can get a lawyer to work for you on a contingency fee. So the lawyer will receive 33% or 40% of what you recover from the employer. And that works okay for a discrimination claim. Sometimes those cases can be worth $100,000 maybe. And so if you have a valuable discrimination claim, you could bring that in arbitration. You could find a lawyer to bring that in arbitration. It's just about whether your case is valuable enough to get a lawyer's attention. And they might be willing to do arbitration. Oh, is it? For the employee. Oh, okay, same thing, yeah. And the plaintiff's lawyers are quite good in the United States. So it's just about whether your claim is valuable enough for them to be interested. Mm-hmm. Okay, I'll talk about more on Friday. Okay, so it depends on what the arbitration contract says. If the arbitration contract says you have to keep the arbitration confidential, then you're not allowed to talk about what happened in the arbitration. But a lot of arbitration provisions don't say that. So what that means is the arbitrator is not allowed to talk about your case, but you are allowed to talk about your own case. So it's private, it's not in a court. So, journalists can't get the records, can't get court records the way they could for a case. But if you want to call a journalist about your Me Too case and say I was harassed at work and you want to call a journalist, unless your arbitration contract says you can't discuss it, and even there's also some exceptions in the law that permit you to discuss it anyway. So yeah, you can call a journalist and talk about your case. Mm-hmm. Oh, it depends on what the collective bargaining agreement says. So, but in general, the collective bargaining agreements tend to have some sort of cause provision. Mm-hmm. Mm-hmm. Hmm? Oh, when the government is bringing a claim. Oh, okay. Or if you're suing the government. Yes. Okay, I didn't understand. Okay, yes. So the government is not subject to arbitration. So that's one of the exceptions is one of the problems we've seen now with all these private employees being covered by arbitration provisions is we're more reliant on the government to bring claims on behalf of workers. And so for example, the government agency responsible for discrimination claims is called the Equal Employment Opportunity Commission. And they are very aggressive litigators, and they will sue on behalf of all employees to recover, for if there's widespread discrimination in a company, they'll sue on behalf of all employees to get relief. So the government is not subject to any of these rules, and so they have really been asked to step in to fix some of the problems with access to justice, but they have limited resources. Oh, so for some things like workers' compensation or Social Security disability claims, and this is not really my area of expertise, but they have kind of an administrative process that you use that's more streamlined than litigation, that's cheaper, and that's faster. And so they have like an administrative judge who oversees it. So those continue to exist. And sometimes you have a lawyer representing you and sometimes you don't. It really varies. So for example, like in California, the California Labor Commission is responsible for wage and hour claims, and you need to make, so in a lot of actually American cases, you have to file with the government first before you go to court. That's actually required for many claims. And those actually have some ADR built in. So when we were doing claims in front of the California Labor Commission, you would usually have a mediation that was presided over by a civil servant, a worker at the Labor Commission who would help you negotiate a settlement. And they were actually very good because they were very knowledgeable about the wage and hour laws. And so they would say like, well, I think this case is worth $20,000. So I think that's what you should pay. That was really helpful for educating the parties and was a good benchmark for understanding how it should settle, and tended to be quite successful for resolving the cases without a hearing. So there is a lot of ADR on the administrative side.
Okay. Thank you again, Professor TIPPETT. Tomorrow morning. Oh, do you have any?
Yes. Two questions. First question refers to one point that you largely commented during the exposition of this morning: the intense use of arbitration in the United States. And as such, the positive fact that the arbitration being used on a large scale can bring to settle conflicts. And imagine a cross-border situation involving, on the one side, a consumer, and on the other side, a transnational corporation. And that the transnational corporations impose on consumer a clause according to which arbitration is compulsory. How do you view this question? Second question: do you believe to be possible to use ADR to settle human rights violations at international level? For example, when a multinational corporation whose headquarters located in one country, a subsidiary is situated in another country. And the subsidiary has not financial resources enough to pay the indemnification. And in this situation, it's possible to use ADR. And let me to ask a third question.
Oh no, I feel like I'm a student in an international law class, which is not my strong suit.
The use of ADR between two countries with different legal cultures, like the United States and Japan, for example, the case you cited initially.
Oh my goodness. Well, there is a whole section of legal scholars in the United States who specialize in international commercial arbitration and the study of international commercial arbitration for international disputes. And those scholars tend to really like arbitration, and they don't have any of the critiques that domestic arbitration scholars have. And I'm not sure why that is. I mean, I feel like there's a long tradition of using arbitration to handle international disputes. And so maybe because of the problem of resorting to courts in different jurisdictions and the difficulty of having to choose one over the other, or the fact that you rely on international bodies anyways, means that people find arbitration to be okay. In the United States, we are seeing more and more of using ADR for human rights related issues. And I'll give you one example, which is the how to compensate people who whose family members were killed in September 11th terrorist attack. And so what the American system did was they set up a compensation system where there was a big fund of money available, and I don't remember where the money came from, maybe partially the airlines or partially the government. And so there was a very famous mediator in the United States who was set up to handle those claims. And so he came up with a system for compensating people based on their age and their, I think it was insurance actuarial tables, to handle each claim with dignity and to make sure everyone was compensated for their lost family members. And Americans really appreciated and valued that system, and they found that it was very fair, and it also spared the families from a difficult, lengthy litigation. So I think Americans will appreciate ADR when it's tailored to the needs of the dispute and provides a way for people to be heard and treated fairly and compensated as best they can in a difficult situation. So I think, you know, they like and appreciate that ADR is flexible and pragmatic in very difficult, very complex disputes. And sometimes ADR is really the only meaningful way to actually address the most complex, most difficult, and sometimes transnational disputes. But this is not my area of expertise by any means, so.
Any additional comments? Okay, no, okay, it's fine. Okay.
So thank you again, Professor. Let's see you tomorrow morning, 9 a.m. Okay.
Okay.
Eu vou com você. Ah, tá ótimo. Eu assino. Depois eu vou só levar o professor. Vai ao professor Alberto, até a sala dos professores, eu volto. Alberto.
I apologize for not.
Oh, okay.
I travel tomorrow morning with the site.
Okay, very good.
I missed to participate in the seminar organized by the Yale School of Law.
Okay. Well, thank you very much for coming.
Thank you.
Thank you for the invitation. And it's great to meet you.
The same.